Short answer, Mike Johnson's a liar, and I do not think they're going, or they have edited the Epstein documents yet. I think the play is to push it to the Senate and have the Senate do that type of dirty work so that when the DOJ ultimately releases the files, it'll be basically giant blocks of black ink and you can't see anything. That's the plan. Why is that the plan, you ask? Well, let's listen to Mike Johnson.
Far more than the discharge petition even anticipates. Chairman Comer is our chair of oversight. Some of the biggest bulldogs in Congress are on that committee. You all know, and I've mentioned this so many times. They have been on the Republican and Democrat side. They're deeply dug in. They've been working around the clock. They worked even through the government shutdown, and there were tranches of documents that were released even over that period. So far, by last count, it's over 65,000 documents, Epstein file documents that are now out in the public for everyone to review. That includes tens of thousands of pages from the Epstein estate, and that includes Epstein's flight logs, his personal financial records and ledgers, his daily calendars, and so much more. And none of that is even written or included in the discharge petition.
Herein lies the problem. The discharge petition was filed September 2nd, 2025. The shutdown occurred when October, so that's about a whole month later. So of course, it's not going to be included in the recent document update because it was filed a month before. So him saying that they've done more is a lie. They've only done more because another representative actually filed to get the Epstein estate to release those documents, thereby forcing the Republicans to update documents they already have on the oversight committee to add those documents in. So he's already bullshitting and lying. It amazes me how people can count themselves as Christians and try to portray this certain level of morality and then just sit there and lie to your face. There has to be some type of rationale in their mind that makes this work because it doesn't jibe with reality. But going on.
From the Epstein estate files. That was produced because of the work of the Oversight Committee that is doing that in a professional, robust manner using the full subpoena authority of the U.S. Congress. From the very beginning, our side has been insistent that this matter must be handled very carefully and with utmost caution and care for the victims. We want maximum transparency. We've always been about that. We want every single person who had any scintilla, there's any scintilla of evidence that they were involved in the Epstein evils, they need to be brought to justice, and it should have been done a long time ago. We need to find out who those people are. But in the meantime, you have to remember there are real people's, innocent people's lives at stake here, and young victims who don't want to be dragged into this political game because it could hurt further what they've already endured. They would be made to suffer more harm if Congress is not careful in what we're doing. And unlike our very important work that's underway in the House Oversight Committee, the Democrat-led discharge petition would carelessly dump thousands of documents without proper protections for the innocent. I brought a chart in here this morning. I want to illustrate for you what we are concerned with. Now, I was a federal court litigator. The members of our House Judiciary Committee, Republicans in particular, have many of these concerns. You have Chairman Jim Jordan and attorneys like Chip Roy, who's running for Attorney General of Texas now. You have Brad Nye, who's a former federal prosecutor, and many members on the committee. Andy Biggs, who's running for Governor of Arizona. They're lawyers, and they understand that the way the discharge petition was drafted is haphazard and dangerous. This is why we have been opposed to this point, okay? And I could be here for a long time going through all the details of it, but the big concern we've all had all along is that the House bill, if it's passed in its current form and it was signed into law, it is dangerously flawed. And our problem and our frustration is there's no way for us in the House to amend it or correct these problems because the authors of the discharge will not allow it. And that's one of our great frustrations. Let me just very quickly, we have a legal document that the lawyers we have all drafted to explain all this. So let me give you five quick, maybe the top 5 concerns about it, and there are more. But as drafted, the discharge petition, it fails to fully protect victim privacy. I'm going to read you an excerpt out of our legal document we put together to explain all this. Congress should give the Attorney General broader authority to redact all the victim information. The discharge doesn't do that. This would prevent the release of information that can be used to unmask victims who have chosen to remain anonymous. Now, you have some very brave women who have come forward and put their names and faces out there and done press conferences and explained that justice is overdue, and our hearts go out to them, and they're heroes. But you have as many as 1,000 women, by some of the accounts, who may be caught up in this. And the vast majority of them have not come forward, probably for obvious reasons. They don't want to be unmasked. But the discharge petition doesn't have adequate protections. It risks re-victimizing those who were trafficked and exploited. And the courts have recognized this concern, by the way. I'll read you a quick excerpt. On August 20th of this year, Judge Richard Berman, the Southern District of New York, issued an order denying the DOJ's request to release Epstein grand jury materials, noting, quote, names and identifying information of victims appear in the subject materials, unquote. Judge Berman then quoted a letter related to the victims' concerns, which stated the following, quote, transparency cannot come at the expense of the very people whom the justice system is sworn to protect, unquote. And importantly, the judge quoted a letter from one of the victims. In the proceeding, she is named as Jane Doe 2. She said this is important to make sure it is of the utmost priority that in any sort of release, all and every detail that could possibly reveal her identities be redacted. The victims of Epstein's evils deserve that protection, and the discharge does not currently provide. Okay. Number 2, the discharge petition could create new victims. Okay, because it requires the DOJ to release information even in cases where the DOJ or the FBI has already reviewed it and determined it is not credible. It is false information. Doing this and requiring this to come out could ruin the reputations of completely innocent people, such as those who may just have known Epstein but knew nothing of his crimes, or whose names he exploited. Think of this: innocent people whose names he exploited and used to try to get close to his intended victims. Their names may be in these files, and they had nothing to do with this. And so by just haphazardly releasing it, you're going to destroy their reputations. Releasing information containing the names of innocent people would subject those innocent people to a guilt by association. It would create an entirely new group of victims who have no means to clear their names. That's a concern of Congress.
Hello, I'm editing. This is probably the only point of contention that I would actually agree with him on, that he has some legitimate things to say about, because people who engage in predation of children have a tendency to obscure or try to hide themselves behind the legitimate. Even in the Epstein case, you had a bunch of people who took his plane, but some of the people who took his plane said, I took it because I went to a benefit, or I took it because I went to concert, for charity. Look at Gary, what was his name, Sandusky? If I recall correctly, he was also kind of a stalwart in his community. He was involved in a lot of things. He did a lot of things with children. He did not assault every child he met. Child predators are very astute when it comes to human psychology of children and adults, and that seems to be a very common tactic they use, is that they try to kind of ingratiate themselves in the community in more legitimate ways and in helpful ways, so that when the rumors start to circulate, you then start to say, oh, well, he can't be a bad guy. For example, he knows President Clinton. He's been with the president, or, he's been with the mayor, or he's started this organization, or he's donated money to this particular cause, or I've seen him help children in this way, right? Effectively, hiding behind the legitimate allows them to muddy the waters. So when the rumors start, it makes it harder for people to believe it.
Should be. Number 3, the discharge in its current form fails to prohibit the release of child sexual abuse materials. That is a term of art. It's called CSAM, okay? It's defined in the U.S. Code. The discharge is so haphazardly written, because remember, it's just a political exercise for these guys. They don't seem to care about this. But they cited the wrong section of the U.S. Code. So when they say that they don't want child pornography to come out, child sexual abuse materials, of course we don't want that released. They wrote this thing so quickly that they cited the wrong section. So you know what that means? It means that it doesn't really bestow any real legal authority on the Attorney General to redact those materials. And that would compel the DOJ to release that stuff into the public. Every single person in this room knows that's wrong, and you should stand against it. But that's what the discharge says. Number 4, it jeopardizes the future federal investigations of the United States. Why? Because the discharge only allows the Attorney General to redact limited portions of records that could publicly identify individuals who were promised confidentiality. In this scenario, you're talking about whistleblowers, you're talking about confidential informants who came forward and gave information and evidence in exchange for agreeing to have their identities not revealed. Violating confidentiality, imagine the chilling effect it would have on future investigations. Who's going to want to come forward if they think Congress can take a political exercise and reveal their identities? Who's going to come talk to prosecutors? It's very dangerous. It would deter future whistleblowers and informants. And the release of that could also publicly reveal the identity, by the way, of undercover law enforcement officers who are working in future operations. Dangerous stuff, and they seem not to care. By the way, I'm going to remind you again, we went to the authors. We asked the authors of the discharge to change this, and they said jump in the Potomac. All right? Number 5, national security concerns, okay? The discharge requires the Attorney General to release within 30 days, quote, classified information to the maximum extent possible. This ignores the principle that declassification should always rest and always has rested with the agency that originated the intelligence. Why? So that they can protect their critical sources and methods. It is incredibly dangerous to demand that the officials or employees of the DOJ declassify materials that originated in other agencies and intelligence agencies. I could go on. I won't be here all morning, but there's a lot of problems. There's also a lot of legal scholars, and I'm among them, who are concerned that you've got problems with grand jury secrecy. We know Rule 60 of the Federal Rules of Criminal Procedure prohibits the release of grand jury materials, but the way the discharge is drafted, you can make an argument that it requires all that to come out, and that is a serious problem. Grand juries are not adversarial, okay? There's no opportunity there for cross-examination. You can't disprove evidence. You can't balance the evidence in any way. And if Congress goes in and breaks that seal and just starts releasing sensitive grand jury materials and allegations like that, it raises a risk that the grand jury process will be politicized in the future. And that's a whole other danger that we can talk about all day. I'm going to wrap this up and just say that Republicans support maximum transparency. We always have. The President of the United States supports maximum transparency. You've heard him say it in his own words. But he has had the same concerns that I've just articulated here. And we talk about that. All of us have had these concerns. We understand that we have a responsibility to innocent people and victims that is not properly guarded by the discharge petition. And that's why we're so concerned about that. We got to make sure that...
He's lying, but let's scrub forward and get to the questions. Because he said something interesting in the questions.
Why not in the name of transparency call on the president to just release the full Epstein Files? He doesn't even need Congress out, so.
Well, the president made very clear his position over the last few days. His truth post over the weekend and what he said, he had a press guy yesterday said the same thing. He says release all the files. He's been saying that. What he was counting on and what we were insistent upon is using the processes of Congress, as I've explained here in great detail this morning, to do it in the right way so that it's not haphazard. And Congress has a role to do that. The Oversight Committee is the appropriate place for this to be done, and that is what is happening right now, as you've all seen. And so we preferred that route. And by the way, as I mentioned, that route is more comprehensive than anything the discharge petition would accomplish anyway, because it didn't even mention the Epstein Files and some of these other things. The state files. So we want the process to play out. We want it to be done the right way. We want to do it in a way that doesn't jeopardize our legal system and doesn't inflict more harm on victims. And the president is...
He's lying. So her question was basically, why didn't you just approve to bring the original bill to a vote in the House as opposed to going through all these legal maneuvering? He never answered that question. Again, the discharge petition came out September 2nd. The discharge petition, let's look at it. So I just asked Gemini, because I was asking it about the case. I said, just be clear, what does the discharge petition do in this case? In this specific case, the discharge petition served as a force mechanism to break a legislative stalemate. While the petition itself is a procedural tool to bypass House leadership, its practical effect was to corner House Speaker Johnson into scheduling a vote he had previously blocked. Here is exactly what the discharge petition accomplished and how it affects the vote happening today. It bypassed leadership obstruction. The problem, House leadership, the Speaker and committee chairs, controls the calendar. If they don't want a bill to be voted on, they simply never schedule it. The Epstein Files Transparency Act, House Resolution 405, had been stuck in committee. The petition's role, by gathering 218 signatures, a majority of the House, Representative Massey and the coalition effectively stripped the Speaker of his power to block the bill. Once the 218 signature was added by Representative Grijalva on November 12th, the House rules require that the issue be brought to the floor. Technically, the discharge petition was filed to force a vote on House Resolution 581, a complex resolution that would have amended an unrelated bill to release the files. However, rather than suffer the embarrassment of losing control of the floor to a discharge petition, which is rare and seen as a sign of weak leadership, Speaker Johnson agreed to schedule a vote voluntarily. The concession. To preempt the petition, leadership scheduled a direct vote on the standalone bill, H.R. 4. This under suspension of the rules, a fast-track procedure. The bill now requires a 2/3 majority, 290 votes to pass, rather than the simple majority of 218 the discharge petition would have required. Summary of the situation. Without the petition, the bill would likely be stuck in committee with no vote scheduled, and with the petition, the House is voting today. The petition acts as a loaded weapon. Even though the House might not technically vote on the petition today, the existence of those 218 signatures is the only reason the Epstein Files Transparency Act is on the floor right now. If today's vote fails to reach the 2/3 threshold, the discharge petition remains valid and can still be used to force a simple majority vote later. That is the petition. So again, Speaker Johnson lies. He could have just scheduled a vote for H.R. 4405, which is the Epstein Files Transparency Act, but he never did it. It was stuck in committee. And now he's trying to say that, well, we only wanted to use the committee because we wanted to help ensure that we don't have any more victims or we don't victimize people further. That too is also bullshit. But let's listen to Speaker Johnson.
I was not satisfied with that. But I've been for maximum transparency from the very beginning. We wanted the process to play out. So,
I understand where you're coming from with your concerns with the discharge petition. I also understand your want for transparency. In this case, you've been very clear on both those fronts for weeks. So is the reason why you're now deciding to vote for this resolution because President Trump directly said Republicans should vote for this? Because this has been your position all along, and you made it clear you weren't in support of this resolution.
If and when the discharge reaches the 218th signature, it will be forced. And the forcing mechanism here prevents the very deliberate, professional, careful manner in which Congress is supposed to do this. I lament that. That's why I've been opposed to it all along. But having now forced the vote, none of us want to go on record and in any way be accused of not being for maximum transparency. So the only intellectually consistent position to have right now, the only way to ensure that both those things are true at the same time, is to allow for everyone to vote their conscience and to go on record to say, of course, we're for maximum transparency. Now, I'll tell you, there's a handful of Republicans, Judiciary Committee members, and a few others who are really struggling, as I have been, about whether or not they can even vote yes today because of this. Because we don't have an absolute guarantee that this will be fixed in the Senate. I have a high degree of confidence in that, and that's why, that's why I'll be voting yes today. And I've talked about that in great, hour and a half long conference call on this.
He said he thinks it's going to be fixed in the Senate. Again, the Senate is what they're banking all of this on. They are banking on the Senate to stall, not them.
Sunday with Judiciary Committee members who are really, really concerned. I mean, they're all for maximum transparency, but they're really, really concerned about protecting the victims, and I am as well, and that's why we have gone through this whole long process.
On that, James Blair today at a Bloomberg event said that they're looking at ways to send millions of Americans checks from tariff to revenue without Congress being involved. Do you have concerns about them not running that sort of process through Congress?
I'm not sure it's possible, and James Blair and I'll have some intense fellowship about that, I'm sure. He's a good friend. We collaborate on strategy all the time, but this is an idea, I think, that makes sense. The president was talking about it recently yesterday. I think what I heard him say, and I haven't talked to him about it because he and I have been so busy the last 24 hours, I'll see him in a little while, but I think what I heard him say yesterday is he's thinking about something maybe midway into next year when the tariff revenue is realized and we can figure out what that looks like. But I think it would require an act of Congress, so we'll have to see how I'm not sure what he proposed.
And by the way, y'all not getting whatever refund check, $2,000, y'all ain't getting that. Listen to this question because she is going to challenge him on the concept that he's trying to prevent harm to the victims.
I guess I'm confused because the bill specifically says the Attorney General may withhold or redact portions related to child sexual abuse materials as defined in the law. Anything jeopardizing federal investigations specifically says they can withhold anything containing personal identifiable information of victims, personal medical files. We know the survivors are comfortable with that. All of these things are actually in this bill. That's why we can
do it for a long time.
what's the
so the first one.
Yeah.
Okay, so here's the first one. This is the page 5. Redact anything that depicts or quote depicts or contains child sexual abuse material TSAM as defined under 18 U.S.C. 2256. Okay, all right. So you go to 18 U.S.C. 2256. Definitions of the chapter. Nowhere in this section, okay, go look it up. All right, does it contain the definition of child sexual abuse material? So I used to litigate federal cases, and I would challenge statutes in court. Okay, the language is very important and very precise. If it's not listed here and this were to become law, child sexual abuse materials are not included. They're not included for redaction, which means the Attorney General and someone there, if they interpret the discharge in the statute that it passes directly and literally as they're supposed to do, they're required to do under the law, then you're going to have things that would qualify under child sexual abuse materials. You have child pornography included in the distribution of this stuff. We can't go for that. And why the Attorney General? No, it's not the Attorney General because the way it's listed in the document. No, it's not. It's not because it doesn't reference the direct code section. So we can go through every one of these things. We've had a small army of lawyers going through it because I want to make sure that all of my concerns, because I read it the first time initially and I thought, whoa, this is way out of bounds. We have a legal, in fact, we'll put it on the speaker.gov, I'll put it on the website here when we leave. You'll see the summary of the legal analysis and it goes through point by point and it points to the specific sections of the discharge. Guys, we're not making this up. You can take it to your counsel at your
So he's saying that it doesn't say that you need to redact child sexual abuse material. So let's go look at the bill. Again, we have the discharge position 9, which is in regards to House Resolution 581. We've already kind of done this summary here. Here's House Resolution 581. And the purpose of this is to make publicly available certain records related to Jeffrey Epstein or Ghislaine Maxwell. It also states inside this particular resolution, however, under the amended bill, DOJ may withhold or redact portions of records with written justification that such portions contain 1. Victims' personally identifiable information, 2. Child sexual abuse materials, 3. Images of death, physical abuse, or injury, 4. Information which would jeopardize an active federal investigation or prosecution, or 5. Classified information. DOJ may not withhold or redact records on the basis of embarrassment, reputational harm, or political sensitivity. And it further states that within 15 days of completing the required disclosures, the DOJ must provide Congress with a report listing all categories of records released and withheld and all redactions made and their legal basis, and all government officials and political exposed persons named referenced in the release materials. So his argument that it doesn't include that, he was trying to say this is not carefully done because it could further harm victims, or it could put people in jeopardy, or it could release classified information. It literally outlines it in this particular resolution here that they are supposed to withhold or redact that. However, they must justify why they did so. That is what this particular part of the bill states. But he's talking about the actual bill itself when he's referencing that section. He's talking about HR 4405. Oh, so what was it? 2256. The Attorney General may withhold or redact the segregable portions of records that A, contain personally identifiable information of victim or victims' personal and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy, depict or contain child sexual abuse, jeopardize an active federal investigation or ongoing prosecution, provided that such withholding is narrowly tailored and temporary. D, depict or contain images of death, physical abuse, or injury of any person, or E, contain information specifically authorized under criteria established by an executive order to be kept secret in the interest of national defense or foreign policy, and are in fact properly classified and pursuant to such executive order. So again, inside the previous resolution, they make it explicit, but inside the actual text of the actual bill that Speaker Johnson did not want to go to the floor for a vote, it also contains that. Now, he's trying to argue that 225 does not define what child sexual abuse material is. And he's the person who apparently reads laws and you have to read them directly or whatever bullshit he was saying. So let's look up 18 U.S.C. 2256. Hello, 18 U.S. Code Section 2256 are the definitions for the chapter. Which chapter are we talking about? This is Chapter 110. What is Chapter 110? Chapter 110, Part 1, Sexual Exploitation and Other Abuse of Children. These are the crimes. This is Code Part 1, and this is all under Title 18. Title 18 includes crimes and criminal procedures. Part 1 includes the definitions of the crimes. Then we go into Part 1, and we scroll down to Chapter 110, which is the definitions of the crimes, and we go to here, and we see that 2256, which he claimed does not define child sexual abuse materials. What does this say? 2256, definitions for chapter. This is literally the section that is defining all of the terminology for this entire fucking chapter. So he's lying. So I guess his argument is that somehow all of these legal people are going to look at this, are only going to look at this particular section, and I guess nothing else. But this section defines what a minor is. It defines sexually explicit conduct. And all of that therein, including bestiality, masochism, sadism. It talks about what producing or the production or manufacturing is. It talks about the organization and who that is. It talks about what visual depiction is and all the mechanisms by it that it can occur by videotape, data stored on a computer or electronic means. It talks about what a computer is. It talks about what the custody of control is. It talks about what child pornography is. It talks about what an identifiable minor is. It talks about the word graphic. So it's very clear what they're talking about. This is literally the definitions for Chapter 110, and Chapter 110 is literally titled Sexual Exploitation and Other Abuse of Children. So if the individuals were minors at the time, even the victims who have come forward, that's not going to be released because they were minors, and you cannot show that. Also, the resolution in question explicitly states that they cannot release things that are supposed to be classified or made secret. The only way they can get around that is if he decides he wants to put out an executive order stating that he doesn't want certain things released. Don't be surprised if he tries that. So again, short term, Mike Johnson's a fucking liar. Long term, the objective is to effectively send this to the Senate so that the Senate can then start altering these bills, Bill HR 4405 and HR 581, and probably the petition itself, so that when it passes, or if it passes, because again, this can be held up by the Senate in committee. And the Senate rules are not the same as the House rules, by the way. I don't know if the Senate has a mechanism that the House has to kind of force a vote on certain bills. And based on those 8 Democrats, who the fuck knows if they'll even be willing to do shit. I don't even know at this point because I don't trust none of them. The point is, They need to take this to the Senate so that the Senate can then either stall on it or rewrite the law in such a way that it gives the DOJ broad power to start redacting certain things so that even if they do get released, you're not going to see a lot. That's the play.